Namaskar on the e-platform of Faculty of Law, GLS University. As per the GLS tradition, we will start with the e-prayer with the program. Here we go.
Shubham kurutvam kalyanam Arogyam dhanasampadah Shubham kurutvam kalyanam Arogyam dhanasampadah Shatrubuddhi vinashaya Deepajyotirnamostute Deepajyotirnamostute Shubham kurutvam kalyanam Arogyam dhanasampadah.
Thank you. With that note, we are today on a very special day, that is Samvidhaan Day, or as we popularly know it as a Constitution Day, that is celebrated in country like India on 26th November. India, as we already know, it is the largest democracy, and in largest democracy, when this day is being celebrated, that too specially by law department at GLS University, it becomes very special. And on this very special day, a special person, and who can be said as the wind beneath the Faculty of Law, that is none other than Dr. Mayuri Pandya, Director of Faculty of Law, GLS University, is there with us. She is an exceptional academician who is rendering quasi-judicial function, being an expert member of Environment Appellate Authority, Government of Gujarat, Environment and Forest Department. She is also instrument to environmental clearness at various projects of national level, being expert member of Expert Appraisal Committee at Ministry of Environment and Forest Department. She is the powerhouse of Faculty of Law, GLS University, and with her high voltage and vibrant ideas, it is the luck and fortune of Faculty of Law, GLS University, that we have various programs and various clinics. We are so happy, and ma'am, I request you to start with welcome address on today's program. Over to you, Dr. Mayuri Pandya.
या देवी सर्वभूतेषु शक्तिरूपेण संस्थिता नमस्तस्यै 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 नमो नमः. I bow down to Vidya Shakti present in one and all who are present on this e-platform, as well as everyone who has joined today for this special lecture. On behalf of GLS University, Faculty of Law, GLS Law College, I welcome Madam, who is a good friend, Shirin, Khajuria Madam, practicing advocate at the Supreme Court of India, a very humble person, very beautiful, and I think that a very appropriate person with us today on this very special day. Ma'am, on behalf of all my students and staff, I heartily welcome you today on this very special day, Constitution Day, that is the 26th of November. We celebrate, everybody celebrates, entire India celebrates this day. We celebrate this day because of the existence of the Constitution of India in 1949 on this very day. So many expectations. If you look back, 1949, and especially when the Constitution of India when implemented. If you just imagine the birth of the Supreme Court of India and the implementation of the 26th, 1950, January, when actually Constitution of India took birth. And if you read the speeches of when the Supreme Court of India was first time when there was inauguration of the Supreme Court of India. The first Chief Justice of India, when he addressed, imagine at that time, whichever the high courts were in existence, all the Chief Justices of High Court, the first Attorney General of India. Imagine that environment. And the first speech of the first Chief Justice of India, when he speaks. And when he said that there are thousands of people, lakhs of people who have faith and trust in us. And we have to abide by the Constitution, being the supreme law of the country. Being a responsible citizen, we are very much aware. Being a law student, we are very much aware of our fundamental rights. But when it comes to the fundamental duty, I think we need to think and we need to question ourselves. After so many years of the existence of the Constitution, today, when we celebrate the Constitution Day, friends, I feel that we need to ask a few questions to ourselves. And remember what Honorable Babasaheb Ambedkar ji, he said when it came into existence. They said that when we constitute our Constitution, the best of the best, we may have our Constitution, but it ultimately depends on the people of this country. And if you see the preamble of this country, it starts from we, the people of India, solemnly resolve. So it is the we. I think when we together, we make the Constitution work, we can, the soul and the spirit, the Constitution is no doubt about it, but I think we are the soul and the spirit of, we can bring that spirit to our Constitution. So with that, so many new challenges in this century, and whatever, whether the fundamental rights, the fundamental duties, the interrelationship between them, emergency provisions, we are well aware. But today, what challenges we are facing? When we talk for the constitutional moralism, right now people are talking for constitutional morality. There are so many challenges that we face, the constitutional challenges we are facing. And today we have one expert who is practicing at the Supreme Court of India and day in and day out who is working for the cause of the public. A truly public spirited person with us, Shirin madam. I heartily welcome you today and eagerly looking forward to listen to you with all my students and faculties. Welcome, ma'am.
Thank you, ma'am, for your warm welcome. I think Shirin ma'am wants to say something. Ma'am?
Thank you. Go ahead.
Okay, ma'am. Now, as Dr. Mayuri Pandya, Director of Director of Faculty of Law, GLS University, rightly mentioned that when the Constitution was constituted, many provisions were there, but it is ultimately we the people. As Article 14 of our Constitution rightly says and talks about equality and all our fundamental rights mentioned in Constitution, but when it comes to implementation, we know that what is the status of implementation of all those articles and all those fundamental rights. So for highlighting that factor, for highlighting the right to equality, Faculty of Law under GLS University is ready to inaugurate a new clinic along with LAC, that is Legal Aid Clinic, Environment Law Clinic, IP Clinic, that is Intellectual Property Law Clinic. Along with that, we are ready to launch a new clinic, that is gender law clinic, which is very important because when we talk about Article 14, when we talk about equality, equality has to be there among all the genders. And for that, we are having our esteemed guest, Ms. Shirin Khajuria, who is a practicing advocate at Supreme Court of India. And as Mayuri ma'am rightly said, beautiful inside out and right person to inaugurate the clinic. Shirin ma'am, with your permission, with just one click, when you say we will be inaugurating due to current situation, it would be e-inauguration. So when you say we are ready with the click to inaugurate, shall we, ma'am? Mayuri ma'am, Suja ma'am. This is symbolic happiness from all the genders for the inauguration of Gender Law Clinic. I would like to request the co-coordinator of this clinic, Ms. Navnita Majumdar, to brief in few lines about the clinic. Navnita ma'am, over to you.
Thank you so much, ma'am, for introducing the Gender Law Clinic. The Gender Law Clinic of Faculty of Law, GLS University, is an initiative with a mission and vision to use law and public policies in all its forms to change culture and drive solutions to the gender inequity that shapes our society and to break down the barriers that harm all of us. The clinic, through legal assistance, research, analysis, advocacy, capacity building exercise, and public education, aims to win policy changes that improve the lives of men, women, third genders, and their families. By recognizing the need of the hour, the Gender Law Clinic aspired to become the leading edge of every major legal and policy victory for disadvantaged genders in India. Now we are going to have a very short presentation about the clinic. Thank you.
Thank you. That was brief presentation about Gender Law Clinic and its vision, mission, and works and features which are planned by the convener of the clinic, Dr. Mayuri Pandya, coordinator of the clinic, Dr. Suja Nair, and co-coordinator of the clinic, Ms. Navnita Majumdar. We wish good luck to all of them from the e-platform. Now, we are coming to the special guest lecture, which is arranged on this special day of Constitution Day, Law Day, on 26 November 2021 from the e-platform of Faculty of Law. We are having with us Ms. Shirin Khajuria, who is the practicing advocate at Supreme Court of India. Just to introduce ma'am in few words, she has completed her law from Delhi University and she joined DCM Shriram Foods and Fertilizer Limited as a legal trainee and then slowly and subsequently enrolled herself as an advocate in 1990. She joined the chambers of Ms. Indu Malhotra, now that is retired Honorable Judge of Supreme Court of India, where she practiced for 4 years before starting her own practice. She has worked briefly with the United Nations Compensation Commission in Geneva, where she dealt with the legitimacy of war claims. She is an advocate on record at the Supreme Court. Though Ms. Shirin Khajuria's main practice has been in the Supreme Court for over 30 years, she has represented a number of clients and companies in different courts and forums, including the Telecom Dispute Settlement and Appellate Tribunal, National Consumer Dispute Redressal Commission, Central Excise and Service Tax Appellate Tribunal, Central Administrative Tribunal, Arbitral Tribunal, and the High Court. She has specialization in indirect taxation and she has diverse practice in environment, commercial, constitutional service, and other civil matters and criminal laws as well. She is also on the senior panel of the Union of India at the Supreme Court of India, and in that capacity, she has successfully defended challenges to the provision of law, including those of the Banking Regulations Act and GST Act along with that. She is also on the panel of the state of Goa and various PSUs as well. She has number of reported Supreme Court judgments to her credit. She was appointed as an amicus by the Supreme Court of India in the case of State of Maharashtra versus Bandhu, reported in the year 2018, where her suggestions that there should be special entrance examination of vulnerable witnesses, including the especially abled people, as ma'am also mentioned earlier, in the interest of conductive environment in court, so as to encourage vulnerable witnesses to make a statement, was accepted, and the High Court have been directed to set up at least 2 such centers in each state. That was really commendable, ma'am. And today, Shirin ma'am is with us to present and to talk about and to enlighten us and all the viewers on Samvidhaan, the soul and spirit of Indian democracy. Over to you, ma'am. Ma'am, you are muted.
Okay. Good afternoon. I would like to thank the director, Dr. Mayuri Pandya, who has a daunting experience, for the kind introduction and for inviting me today to inaugurate the Gender Clinic and also to commemorate this August date when we adopted our Constitution 72 years ago. Thank you for also drawing our attention to the fundamental duties, Dr. Pandya. I would like to thank the faculty members, particularly Dr. Payal Mehta, for the kind introduction, and also Dr. Suja Nair and Ms. Navnita Majumdar, the coordinators and the co-coordinators of the legal clinic, and for the very interesting presentation, which was really inspiring. I would like to thank the student organizers of this student. A very good afternoon to the faculty and to you, the young legal fraternity from the law faculty of GLS University. Your college was established by one of the oldest law societies in Gujarat, and it's my absolute privilege and pleasure to be here with you today. I congratulate the university for establishing the Gender Law Clinic, dedicated to the powerful mission of creating more inclusive and safe environments in which the social, economic, political equality can be realized by the people of all the genders. This clinic will further promote our constitutional values. The value of living with dignity cannot be understated. as we talk about this on this Constitution Day, I would like to begin by referring to some excerpts from a landmark judgments, which I think are important to critically engage with. In the case of Nalsa versus Union of India, where transgender person was recognized as a separate gender, Justice K.S. Radhakrishnan, referring to Article 21, stated as under, if I may quote, "The heart and soul of the Indian Constitution, which speaks of the rights to life and personal liberty. Right to life is one of the basic fundamental rights, and not even the state has the authority to violate or take away that right. Article 21 takes all those aspects of life which go to make a person's life meaningful. Article 21 protects the dignity of human life, one's personal autonomy, one's right to privacy, etc. The right to dignity has been recognized to be an essential part of the right to life and accrues to all persons on account of being humans." Unquote. In the case of Suchita Srivastav, it was held that the consent for medical termination of pregnancy of a mentally retarded woman is essential, while distinguishing her from a mentally ill person. In the celebrated case of Navdeep Johar, which has decriminalized homosexuality recently, Honorable Justice Ms. Indu Malhotra famously said, "History owes an apology to the LGBT community and kin." I believe this clinic is one of the first of its kind in Ahmedabad, and I would exhort each of you to work with the clinic, to support its mission, and to do what it takes to build a more egalitarian community around you. I wish all success to this wonderful clinic. Coming to the discussion topic for today, I have been requested by Dr. Mayuri Pandya to share with you my thoughts on the topic, Samvidhaan, the soul and spirit of Indian democracy. Legal discussions and documents often begin with definitions in the hope that we are objective. So let me begin by defining Constitution in the words of Hans Kelsen, an Austrian-American jurist. He defined it as a, quote, Grundnorm, a basic norm whose validity is presupposed and from which the validity of all other norms is drawn, unquote. In other words, a constitution is, as most people relate to it, the supreme law of the land, from which the other legislations draw their power and authority. I also think of the constitution as our collective conscience, a set of principles that govern our way of life. Any conversation about our constitution is incomplete without the mention of democracy. The Honorable Supreme Court has observed in the case of T.N. Sheshan versus Union of India that unquestionable democracy is an indispensable feature of our constitution. How then do we describe democracy? Would you all like to just make a note of it on your sheets of paper or do it on the chat box? In the words of the founding father of our constitution, Shri B.R. Ambedkar, democracy is not merely a form of government. It is primarily a mode of associated living, of conjoint communicated experience. It is essentially an attitude of respect and reverence towards fellow men. In other geographies, the famous French philosopher Rousseau has called democracy the general will of the people, a collectively held will aimed at achieving the common good. Abraham Lincoln defined democracy famously as government of the people, by the people, and for the people. This brings me to what is broadly referred to as political democracy. Political democracy refers to universal adult franchise. It is the basis of a representative form of government where we have the right to elect those who represent us, and it is through these representatives that our collective will is executed. As stated in the case of Kesavanand Bharti, democracy proceeds on the basic assumption that the representatives of the people in parliament will reflect the will of the people and that they will not exercise their powers to betray the people or abuse the trust and confidence reposed in them by the people. We now move on to the social and the economic aspect of democracy, which deals with our basic rights and freedoms and the constitutional remedies. As our Baba Sahib said, and I quote him, "The right to constitutional remedies is the heart and soul of our constitution." Unquote. Part 3 of our constitution guarantees us fundamental rights and freedoms, which includes the right to freedom of speech, expression, association, and assembly. We also have the right to equality, life, and liberty. The Golden Triangle, as it was called in the case of Maneka Gandhi, that is Articles 14, 19, and 21. Democracy then is essentially an institutionalization and realization of these freedoms, is how I would put it. Reading different definitions of democracies brings me to this. Put simply, at the heart of democracy is a desire, demand, and need for being heard, seen, and felt by those we elect to represent us, and also by our community. I would like to share with you the background of the case of state of Maharashtra versus Bandhu, where I was appointed an amicus by the Honorable Supreme Court. The rape victim was an 11-year-old mentally retarded deaf and dumb girl. The rapist was acquitted by the High Court on the ground that the victim had not been produced, and the evidence of her mother was held to be mere hearsay. I have seen that in most such cases of differently abled persons, whether the witnesses are vulnerable, they are shielded by their family from what they perceive is the harsh court system, and so often they are not produced as a witness. In fact, in most cases, even the police and sometimes the judiciary does not realize that they are good, capable witnesses. It was in these circumstances that I had suggested we have special centers where such vulnerable witnesses depose rather than the regular courtrooms. In fact, this is a concept which is not alien to other countries and has already existed. They do not have to come face to face, such vulnerable witnesses, with the accused, as there is a screen that divides them from the accused. In fact, even the entrances are different, so that there is no occasion to come across each other and there is no fear factor. The cross-examination is also only through questions put by the judge. The Honorable Supreme Court was pleased to accept the suggestion and has directed, in fact, all the high courts to have at least 2 such centers in the trial courts under them. I am not sure if Gujarat has the 2 such centers. Maybe one of you could just check that and otherwise ask for enforcement of the judgment. This judgment, I believe, is an expression of humanism and inclusiveness. I would like to quote Honorable Justice G.Y. Chandrachud, who in the case of Puttuswamy, in his plurality judgment, speaking on behalf of the 3 other judges and himself, has observed that, and I quote him, "Life and personal liberty are not creations of the Constitution. These rights are recognized by the Constitution as inherent in each individual, as an intrinsic and inseparable part of the human element which dwells within. Life and personal liberty are inalienable rights. There is inseparable relationship between protection of life and liberty with dignity." Unquote. More importantly, he emphasizes that human dignity is an integral part of the Constitution, and that constitutional value of dignity finds expression in the preamble, which presents the constitutional vision of the realization of justice, liberty, equality, and fraternity. Modern democracies have been described as spaces of reason by Mr. Lynch, if I remember rightly. As Honorable Justice G.Y. Chandrachud mentioned in a recent lecture, the true test of a democracy is its ability to ensure the creation and protection of spaces where every citizen can voice their opinion. He also said that dissent is a safety valve of democracy. Dissent has been recognized as a symbol of a vibrant democracy in many recent judgments of the Honorable Supreme Court, especially in the context of crackdowns on peaceful protesters or peaceful expression of opinions by the citizens. It has held that voice in opposition cannot be muzzled by persecuting those who take up unpopular causes. I think it's well summarized in the case of Puttaswamy, where it says, I quote, neither life nor liberties are bounties conferred by the state. I think it's extremely important for us to understand this. Although I have spoken a lot about it, interestingly, the word democracy is used only once in our long constitution and in its derivative form in the preamble. The preamble, which is known as the spirit of the constitution, begins with, I'm sure you all know that, but I would just like to remind you of it. We, the people of India, having solemnly resolved to constitute India into a sovereign, secular, socialist, democratic republic. As stated in our Constituent Assembly debates, it is essential to understand that the responsibility of fostering a constitutional culture falls on the shoulders of both the state and the populace, which is we, the people of India. As Dr. Pandya had reminded us in her talk, our fundamental duties are extremely important and have been added by Chapter 4A to the Constitution. It is in this spirit that I say that the Constitution is also an embodiment of hope. In times of sectarian politics, amidst attempts to invisibilize the fault lines of our society, such as caste, religion, gender, sexual orientation, the Constitution is an embodiment of the aspirations of citizens of this country. It's an embodiment of our current aspirations as a society where we are failing. We must continue to strive to be better, and each of us must begin now. Quoting Martin Luther King Jr., our lives begin to end the day we become silent about things that matter. The Supreme Court has protected the principle of democracy by intertwining it with the basic thread of constitutional morality. The soul of democracy is its people. The spirit of democracy lies in the freedom of speech and expression provided to its citizens under Article 19(1)(a), which is of course subject to reasonable restrictions. It means that every citizen can freely express herself without fear of persecution or reprisal. This freedom has been expanded recently to include the right to information, the right to fly the national flag, the right to education, gender identity, etc. In the case of Shreya Singhal, it was in fact one of the students who had filed this case. Section 66A of the Information Technology Act was challenged. Honorable Mr. Justice Rohington Nariman, speaking for the bench, said that protected and innocent speech cannot be curtailed on the vague ground that it is grossly offensive. What annoys or offends one may not have the same effect on another. The recent interim judgment in the case of Pegasus spyware has brought a general sense of catharsis, I believe, to the democracy, where there was an apprehension that the voice of dissent was being muzzled. The spirit of the order appointing a high-powered committee to look into the irregularities makes it emphatically clear that privacy is now a well-established constitutional and democratic right, which cannot be sacrificed on the vague plea of national security. It must, however, not be forgotten that there are reasonable restrictions on the rights and freedoms, which are there to ensure the smooth functioning of the state and to prevent the rights of others from being infringed. Also, the freedoms guaranteed in a democracy must be exercised with a sense of responsibility and duty. There are no absolute constitutional liberties, please remember. Democracy is based on a balance between constitutional rights and public interest. As stated by the Honorable Supreme Court in the case of Shaheen Bagh, or the CAA case as it is more popularly known, democracy and dissent go hand in hand, but then the demonstrations expressing dissent have to be in designated places alone. The present case was not even one of protests taking place in an undesignated area, but was a blockage of a public way which caused grave inconvenience to commuters. We cannot accept the plea of the applicants that an indeterminable number of people can assemble whenever they choose to protest, unquote. In the recent past, expression of dissent by means of peaceful protests have drawn the attention of the courts and legislatures to the will of the people. The candlelight protest in the Nirbhaya case across the country drew attention of the courts and the legislature to lack of safety and protection of women against sexual assault. It resulted in the quick conviction of the perpetrators, and in 2013, there was an amendment in the CRPC for speedy trial in such cases of sexual assault. The recent announcement of the government to repeal the 3 farm laws after a year-long protest by the farmers on the ground that they were unable to explain the benefits of the laws to the farmer is another example of the robustness of our democracy in the present constitutional framework. I would like to conclude only by saying that the Samvidhaan and the concept of democracy are dynamically static. The Constitution is a living document, evolving and adapting to new circumstances and changing demands of democracy, even without formal amendments. I look forward to each of you being the element of change. As our revered father of the nation, Mahatma Gandhi has said, be the change that you wish to see in the world. Thank you so much.
Thank you so much, ma'am. Thank you so much, ma'am, for your kind words. Now it is the time for open floor, ma'am. With your kind permission, if you permit, we have some questions today for this session. With your kind permission, ma'am, can we? Yeah,
sure.
Thank you so much. Just.
Sure.
Ma'am, thank you. There is a question from our student who wants to ask that according to you, which is the most important article in the Constitution of India, and moreover, according to you, what is that one mistake that made while framing the Constitution? These are very first year students and they are curious about certain things, ma'am.
Very interesting question coming from a first year student. I'm very impressed because I think in the first year, you don't even really get too much into the Constitution. Do you? Do you have the Constitution in the first year?
No, ma'am, they do not.
I don't think you have the Constitution. Yeah, good question. Okay, so I would say the golden triangle, as has been said in the case of Maneka Gandhi, 14, 19, and 21. And well, personally, of that, I would say 19(1)(a) and 21 is which I believe personally are the most important. But yes, technically, it's all three which are the most important. Now, to ask me any one mistake that you think in making the Constitution, well, it's interesting, you know, that our Baba Saheb Ambedkar, who's the founding father of the Constitution and who'd worked on it for so many years while making it, I do not know if you know it, that a few years after he framed the Constitution, he said, I would like to burn it. He said, I do not think it helps any of those people whom it was meant to help. So frankly speaking, after that, who am I to say where is the fault? There are faults, but I think we have managed, I would say, to deal with them and still move ahead. Does that answer your question to some extent?
Yes, ma'am. He's saying yes, ma'am. Thank you.
Welcome.
This is the another question from our student Tirth. That as an advocate and as a citizen of India, if given a choice, what amendment it would be which you like to make to the Constitution of India?
What amendment would I like to make to the Constitution of India? No, I think I'm happy not making an amendment. I like the interpretation. You know, there is so much I can do by interpreting it, like the courts have done in the recent past. You know, they've interpreted 14, 19, and 21 so beautifully that we didn't really need an amendment. You know, like I was talking about the amendments, including the third gender person. And then you have decriminalization of homosexuality. You have so much of equality. You have the opening up of the Sabrimala. So you have so much that is happening without an amendment. So I would just say that I would try and, you know, assist the court in interpreting it in such a way. It's given us a lot of opportunities. It's a very flexible, live document.
Ma'am, Dhruv wants to ask that, would you please explain that what are the controls on the abuse of administrative discretion in India, according to you and as per your experience?
See, as far as administrative discretion is concerned, a lot of it is by the legislation which is subordinate to the Constitution. The Constitution lays down the broad contours, you know, of the powers. You have the elected representatives and you have the governor. So that is, of course, laid down in the Constitution, and thereafter you have others. In fact, in the recent case of NCT of Delhi, you know, where there was this dispute between who has primacy, whether it is Chief Minister of the Delhi state, which has a special status. It's a union territory, and yet it is like a state because it has a legislature, or whether the LG is supreme. So in that judgment, in fact, the court has put it very beautifully. I don't have really the court just now, but it said very beautifully that both of them must work in harmony. You know, that's what the Constitution provides for. It provides for both of them. But it must always be remembered that the will of the people is finally expressed by their elected representative, who is the chief minister. So the court hasn't really said who has the primacy. It has said that you must both work in harmony, but it has made it clear that the voice of the people is through the chief minister and his council of ministers.
That why is right to constitutional remedies considered as heart and soul of Constitution?
You
Why
tell
not
me.
anything else?
I would ask the person to tell me, why do you think that? Aren't we all here? We realize it as law students, as lawyers. I mean, whenever there is an infringement of a right, that's where we go to the courts for. So constitutional remedies, I would say, is what we are all practicing. It's the heart and soul. If we didn't have this option of coming over to the courts and remedying a wrong, the entire Constitution would have no meaning. In fact, during the emergency, that's what they tried to do. They tried to take away the heart and soul of the Constitution. And it was said, no, there is this basic framework. People were put behind bars, and and they said there's no right to life. So if you had something like that and you didn't have a constitutional remedy, what would you do? So yes, I would say it is definitely the heart and soul of the Constitution and us, our lives. Does that answer your question? I can't hear you. Sorry, I
Yes, the
can't hear you.
person is saying that yes. Nabil
Okay,
has said yes. He has
okay.
got the answer that he was looking for, ma'am. And
Okay,
I think
I'm
it is in
glad.
the continuation that Susan wants to ask that what is meant by limitation of constitutional rights? Can you
Right.
explain it with some examples so that they will be able to understand, ma'am?
Right. So I will come back to the Shaheen Bagh one. That was one of the examples which I gave. But if you have a look at, say, Section 19, sorry, Article 19(1)(a) and the other articles under 19(1), all of them have the concept of a reasonable restriction. So the restriction could be in the interest of the public. It could be in the interest of national security. So it is the test of a reasonable man. See, there is a common saying which goes, which you might have learned when you were in school, that your freedom ends where my nose begins. So you cannot encroach upon somebody else's freedoms, right? So that is why there is a reasonable restriction. So you might have the freedom of speech, but you cannot abuse me in the public without any background to it. It cannot be a false abuse of it. That will be totally tarnishing my reputation without any basis. So that is not permissible. And then, as we had also mentioned, the case of Shaheen Bagh, where there were these protests against the CAA bill. So what had happened in that case was these people had sat on the road and they had actually blocked, commuters in Delhi. And so, to that extent, the court said you have a right to protest, you have a right to dissent. There is no problem. But there are certain reasonable restrictions. You cannot block the commuters because that's when you are hurting the rights of the others to free movement. So that's why you have the restrictions. Yeah.
Thank you,
Susan,
ma'am.
anything else?
Next
Yeah.
question is from Devanshi, again our first year student. She wants to know that what are the emergency provisions relating to the failure of the constitutional machinery in the states?
Sorry, could you just repeat the question? I don't think I really got it. What are the?
Sure, ma'am. What are the emergency provisions relating to the failure of constitutional machinery in the states?
So that is when you have the central government, which has the power then to declare that the state government does not exist anymore. That's a whole topic by itself, is what I would say. Yeah, it's you won't really be able to take it up in this today. That's a complete machinery that is provided under the Constitution. That in case there is a failure of the individual states, then how the center steps in. Yeah.
How does Indian Constitution?
Yeah.
Yes, ma'am. How does Indian Constitution limits the power of the government?
I would say primarily by giving you the rights under Part 3, because you have the rights in case the government is not working within the limits that it is expected to. You have your constitutional remedies under Part 3. Yeah.
Couple of questions only because students are so curious about certain things.
Sure.
Susan wants to know about the official language wala article, which is article number 343. Can you please throw light, shed light over it? That what is the difference between official language and formal language?
A formal language, I don't think is really defined in over here. So in like we have so many dialects and languages in India, and I guess it would be difficult to really accept all of them. I think there are thousands of dialects and sub languages. Right.
Yes,
so I think that is why we have Article 343, which recognizes the ones which are most commonly used. Yeah, so you have, of course, Hindi, which is the main official language, but then you have some of the others which are widely used in the country. It may not be possible to, have those hundreds of languages that we have all included in the schedule because it might become difficult to communicate. So you need to limit them a little only for the ease of communication in this vast country. I think that's why we have Article 343 limiting it to those mentioned over here, the official languages.
Yes, ma'am. The student is responding. Got it. And thank you, ma'am.
Welcome.
Again, all those whom you have answered, they are just thanking you, ma'am.
Most welcome. You're most welcome. You can ask me any questions anytime later. You want to email me, you can email me too. It's a pleasure to
ma'am
give
has
you
said,
answers.
as ma'am has said, with ma'am's consent, we'll share email of ma'am. And when ma'am is having time and when she gives kind consent, we'll be sharing it with them. Ma'am, we are also having facility of internship. I'm sure in coming year, whenever they will have or they'll need some help regarding that, you will be there for our students.
I'll definitely be there, and you can share my email with them anytime. It will be a pleasure to interact with students. You know, they are the coming generation. They are the ones who will bring the changes, some of which we haven't managed to do as yet. So I definitely look forward to further interactions with them, and we hope we can help them in a way, you know, which will possibly help them change the future.
Okay, ma'am. There's another student who wants to ask that, do you feel that sedition law is somewhere a threat to Indian democracy? Do you think so?
So that's what it has been. And I think that's why the Supreme Court and the other courts have intervened. And they have tried to water it down, is what I would say, and interpret it so that it isn't a threat to our democracy and to our state. Yes, it depends upon the interpretation, again, is what I would say.
Yeah. Okay, ma'am. I think considering the time, this would be the last question for our session. It is for the student Charishma is willing to request you to shed some light on substantive provision of a constitution.
Substantive provisions of the Constitution. So I would say the Golden Triangle, 14, 19, and 21. You know, that I would say is the heart, as they have said, and the soul. I would call it everything. It's the heart, it's the soul, it's the spirit of the Constitution. These three articles. They are the ones which give us our freedoms. These are the ones which give us our remedies. Yes. I can't hear you. I'm so sorry.
Yes, ma'am. All the students are willing to share that it was a nice session, great session, and they listened to you and they learned a lot.
I'm so glad. Thank you so much. Thank you so much for your feedback.
A few questions are there, but we are just considering the time limit. And Rachit, Tejas, as ma'am said, will take up your questions afterwards.
Sure. If you want, I can take up one more question. If you're okay with it, I'm fine with it. I can take up one more.
Okay, ma'am. If you allow it, it's completely okay.
We can take one more question.
Yes, ma'am. It is from Rachit, who wants to ask that as an honorable citizen and advocate, as we see in us constitutional criminal trials are adjudicated by a grand jury. Is that help in decision making, and that is that it can be done in India also, which happens in other countries?
Right. So you might know that we did have the jury system earlier. And, you know, it's interesting to see how the jury system functions. I had, in fact, seen one in Scotland. And I think it has advantages as well as disadvantages. So the part that I saw was when they were selecting the jury. And they spent a whole day in just selecting, you know, 3 members of the jury. So I do not know, you know, in our country where we have not too much of time, firstly, and secondly, where the levels of education may not really be the best. I personally feel it was a good idea to do away with the jury.
Okay, thank you, ma'am. I think other questions you have already answered. So students, if you have more questions, you can go through the link once again and you can come back. And these are just the views of the students which they have expressed.
Okay, sure. I will just check that out. I need to.
This is just the views that it is the pleasure to hear you, and it was really wonderful and impactful session. That is what it is being said.
Thank you so much. Thank you so much, each one of you, for being here, for listening, and for your appreciation. And any time that I can help you, I would be really grateful. And of course, as I've already spoken, with the faculty, there are certain areas where I'm looking your help, where I'm hoping to, that we could possibly do some pro bono matters. So yes, I'm looking forward to further interactions with all of you. Thank you
Thank
so
you,
much
ma'am.
for the
Thank you,
opportunity.
ma'am. Just a minute. It is the time for official vote of thanks for the session. I would like to request the coordinator of Gender Law Clinic, Dr. Suja Nair, to propose vote of thanks. Over to you, Suja, ma'am.
Good afternoon to all the viewers of this special session on e-platform of Faculty of Law, GLS University, to celebrate the Constitution Day. This special lecture has definitely been enriching and enlightening. On behalf of Faculty of Law, GLS University, I would extend my earnest gratitude towards the special guest for today's event, Ms. Shirin Khajuria, Advocate, Supreme Court of India. It was really a pleasure to listen to you, ma'am. The concept explained by you in today's session, I'm sure has benefited the student and would have guided them about the less known perspective of our Constitution. A special thanks to ma'am for inauguration the Gender Law Clinic on this auspicious day for us, the Law Fraternity. I express my gratitude towards our director, Dr. Mayuri Pandya. Her never ever give up. The attitude is the reason why Faculty of Law keeps organizing very successful events. It is her vision that Faculty of Law has set up various clinics like Legal Aid Clinic, Environmental Law Clinic, IP Clinic to benefit the students and the society. And now, to serve and aware the society about gender issues, we have inaugurated the Gender Law Clinic. Thank you, ma'am. I thank my Faculty of Law family members for their involvement in the event. I also like to thank Krunal Bhai for all the technical support. And lastly, a big thank you to all the participants for being virtually present at the event. Thank you.
Thank you so much.
Thank you so much.
Thank you, Shirin ji. Thank you.
Thank you so much. Thank you.
Thank you, everyone. We are signing off from the session now.